We'd like to continue on with the immigration update on there with Attorney Jack Golan, whose offices are located at One Park Plaza in Los Angeles, California. The exact address is 3250 Wilshire Boulevard. Attorney Golan, many questions about green card and citizenship applications. I guess this is the best time to apply for citizenship, correct? Because it's almost election time. The process, they say, becomes quicker.
The best time to apply for citizenship is as soon as you are eligible.
I see.
Don't wait.
It's interesting how, Attorney Golan, there are just some people who had been waiting. Now, there are still people that talk to me and still say that they would have to be green card holders and remain as residents because they have a pending petition with their children back home. Is that true?
No, it's not true anymore. For a long time, not true. Because Congress passed a special law saying that if you petitioned for your unmarried son or daughter in the F2B category, and now you become an American citizen, which would upgrade the petition from F2B to F1, and in F1 the waiting time is longer. Then your beneficiary, your son or daughter, if they are still unmarried, are able to make a special request to retain the F2B category, not to be upgraded, and to retain the same priority date like before. And the fact that the petitioner became an American citizen would not affect the waiting time of the son or daughter.
Mm-hmm. And so for those people, Attorney Golan, that tell us that they're waiting because they have a pending divorce, a pending adoption of some children in other countries, and of course the number of months that they have to stay, because there are just people that go home every year and sometimes stay on for months. How many months would you have to stay in the United States, continuous residence, before you can really apply successfully for citizenship?
The calculation is not easy, not simple. First of all, you have to, let's talk about somebody who has a green card, not on the basis of marriage, because on the basis of marriage, the times, the calculations are a little bit different.
Mm-hmm.
But somebody who got a green card based on employment or based on a parent's petition or brother and sister petition, okay, such a person must have had the green card for at least 5 years, which means cannot even think of applying before 5 years.
Wow.
And then must accumulate at least half the time, which means 30 months, which is half of 5 years, 2.5 years of physical presence in the United States. The physical presence need not be in one chunk of time.
Mm-hmm.
It can be in little pieces of time, 3 months, and breaks, and 8 months, and 2 months, and this way to accumulate 30 months. It does not need. It is not necessary to accumulate the time in a consecutive manner, the 30 months, which means that anytime you apply for citizenship, you need to meet at least, first of all, a requirement that your green card is at least 5 years old. Secondly, that during the last 5 years, you have been physically present in the U.S. for at least 30 months. And also, that during the last 5 years, you never were absent from the United States for more than 6 months at a time.
I see.
So if you left the United States for 7 months at any time, your count begins afresh.
Mm-hmm.
So if you really are anxious to become an American citizen, you should not leave the U.S. for more than 6 months at a time. Always come back a little earlier than 6 months.
What could be the reasons why a residency can be taken away from you, Attorney Golan?
Well, first reason would be that you overstayed outside of the U.S. for more than 12 months without a re-entry permit. If you left the U.S. for more than 12 months without having a re-entry permit, your residency expires. This is one reason. Another reason has to do maybe with criminal convictions. If you had some kind of criminal conviction and which amounts to a more serious case, then the Immigration Service may start deportation proceedings against you and take away your green card.
Mm-hmm.
Okay? And another reason maybe is that the Immigration Service discovers that when you applied for your green card, something was wrong with your application. For example, if you were petitioned by your parent as an unmarried son or unmarried daughter, where in reality you have already been married. Okay, so this is a big, bad defect in your application, in your green card.
Mm-hmm.
So this is another reason why a green card may be taken away from you.
For those people who have inquired and would like us to direct their questions to you, Attorney Golan, someone who has a pending divorce and another individual, without mentioning their names, of course, who have pending civil cases in court, will these be reasons for them to delay their application for citizenship?
Civil litigation is probably never any reason to delay citizenship. A divorce raises the question: how was a green card obtained? If it was obtained by a petition of an American spouse, then a divorce or a pending divorce may delay the citizenship because the requirement changes from 3 years to 5 years. Normally, if somebody obtained a green card by marriage and is residing with the American citizen spouse for 3 years, then they may apply for citizenship. They don't need to wait 5 years. But if before the end of those 3 years the marriage falls apart, then they do need to wait 5 years.
Mm-hmm. For more information, please call Attorney Jack Golan for free initial consultation, 213-383-3222. Once again, write down their office address. That's 3250 Wilshire Boulevard, Los Angeles, California, 90010. And that's at 1 Park Plaza. Stick around for more information on Immigration Update on the Air. This is AWEE Abayari reporting.